This program is brought to you by Emory University.
Okay, welcome everybody, including those of you still milling around and chatting and so on. Let's get started with the last panel of the day. We're the only thing standing between you and refreshments at the end of the day, so we need to get rolling. First of all, as other moderators and panelists have done, I want to thank, in a very personal way, the Thrower family for what they've done for this law school. I have seen it over many, many years. I was here as Associate Dean when the Thrower lectureship was first established and worked with the family on establishing it, and it has been transformed by its delegation of operations to the Emory Law Journal in all of the best kinds of ways. Students have built it up in wonderful ways, to a symposium from a simple single speaker and to a signature part of this law school's intellectual enterprise and a volume of the Emory Law Journal every year. Judge Kosinski mentioned Randolph Thrower as an able advocate before him. I was a junior associate when he was the most senior of senior partners at Sutherland, Aspel, and Brennan. And some of you may have heard stories about his principled pushback as IRS commissioner from Nixon White House proposals to use the IRS as a tool against political enemies. I just want to simply say that for me, Randolph Thrower was an inspiration in how he practiced law for his clients, but maintained his professional independence at the same time. As one who just kind of observed and learned as a junior associate, he pushed things to the limit, trying to practice law as perfectly and as ably for a client as he was able to. At the same time, on one occasion, when I was rotating through the tax team, I was privileged to hear him tell a client, "We can't do that for you because that would be illegal." And that would be tax evasion, not simply trying to minimize taxes. And that was a signal moment in my own understanding of the line between what a lawyer does to represent a client and otherwise. I don't know, incidentally, whether that client stayed with the firm after I came to Emory Law School, or whether that client looked for a lawyer who would be a little more malleable. But at any rate, I was always appreciative of Randolph Thrower's professional leadership. The other panels today have had it easy. They've dealt with privatizing justice, state and local services, and health care. This panel will wade into more difficult shoals to talk about privatization abroad, especially in conflict zones. I think not only of Afghanistan and Iraq, the obvious ones, but also Libya, Pakistan, Yemen, elsewhere. The complications abound. Here are 6 ways in which they abound. One, there's distance. That stretches control, often obscures democratic accountability and control. 2, there are serious jurisdictional issues and potential conflicts with other sovereigns when we privatize overseas. We don't have those conflicts at home, particularly with, in the federal state area, a supremacy clause. Third, domestic legal frameworks are overlaid with international law considerations to a much greater extent than in any of the previous panels' discussions. We have treaty commitments, we have international human rights law, we have international humanitarian law, which is different from international human rights law. International humanitarian law is otherwise known as the law of armed conflict. Fourth, we have cultural contexts that change dramatically when we move overseas. In very profound ways, when we move to a country in which corruption is rife, lack of respect for human life, particularly female human life, or particularly human life from other ethnic groups, changes, we've got something that is a change in kind that affects how we do things and what we do overseas, particularly when we start talking about privatization. You know, for example, just a simple example, in Afghanistan we offered $5,000 bounties for those who would turn over Al-Qaeda and Taliban figures. As a result of that bounty, not surprisingly, and this is an instance of privatization, a large number of Uyghurs who were ethnic Chinese who opposed the Chinese government and are Muslims themselves wound up in Guantanamo, though they were neither Taliban nor Al-Qaeda. Fifth, the stakes rise. We add the national security context to what we're doing, and we move from issues that are mainly about contract dollars, efficiency, and public values generally to dimensions of life and death, oftentimes and even more generalized and profound than in many areas of healthcare. Sixth and lastly, if anything is a core government function, at least under the U.S. Constitution, surely it's national security. We might argue whether providing health care is a traditional government function. Education, which at the beginnings of the Republic was done privately or not at all, is a traditional governmental function. Or even prisons, historically, are they inevitably governmental? Well, I don't think we're going to have much argument about that with respect to war, though of course when war morphs into counterterrorism and asymmetric warfare with a non-state entity like Al-Qaeda, we might argue about things. Anyway, we have three panelists today, and they are wonderfully equipped to deal in various ways because of their backgrounds and their focus on these particular issues to which the panel is devoted. First, Dan Gordon is the Associate Dean for Government Procurement Law Studies at George Washington University. He has a BA from Brandeis, an MPhil from Oxford, a JD from Harvard. All these folks, incidentally, are highly credentialed. But anyway, before he came to GW, he was the administrator for federal procurement policy. And before that, he worked for 17 years in the GAO. If anybody has struggled on the ground and in theory with procurement issues, including those overseas, it's Dan Gordon. He's worked with many U.S. foreign and international entities to improve acquisition policies, practices, and training, including federal agencies, the World Trade Organization, UN Commission on International Trade Law, and the World Bank. Secondly, we're going to turn to John Michaels. John hails to us from UCLA Law School. His educational background is from Williams College, Oxford on a Marshall Scholarship, and Yale, where he got his law degree. He's going to be a visiting professor at his alma mater at Yale this coming year. But at any rate, John's principal interests are in the intersection of administrative law, national security law, and separation of powers, looking most recently at innovative private-public collaborations and legal and normative challenges to such collaborations. And that's what he's going to talk about today, trying to see how you hold contractors accountable in military privatization and private-public partnerships overseas. Thirdly, Laura Dickinson, who has recently moved from Arizona State University to George Washington, where she's the Oswald Symester Colclough Research Professor of Law. She went to Harvard and then to Yale Law School. Laura has recently published a monograph entitled Outsourcing, War and Peace, published by Yale University Press. And what she does is she looks at privatization of military security, foreign aid functions of government, the impact of this trend on core public values, and works with mechanisms to protect these values in an era of privatization. And Laura today is going to focus on a new international code of conduct designed by the private contractor industry, governments, and human rights organizations to solve some of the daunting problems of overseas privatization. She'll assess this mechanism in terms of the metrics of public participation, accountability, and transparency. So our format is going to be about 15 minutes per speaker, and then we'll open things up to questions. So first, Dan, your turn.
Charlie, thank you very much. It's a great pleasure. It is an honor to be invited to participate in the symposium. I want to thank the organizers and the sponsors. I have to tell you, Jessie Brown in particular and her colleagues get lots of thanks. There were an enormous number of logistical issues that needed to be arranged, and everything was arranged flawlessly. Much appreciated. I've organized conferences, and I know how tough it can be. I also want to point out that the way the program has worked today, I thought it has been particularly helpful. Hearing experts in different areas, people with different backgrounds, talking, whether it was everything from parking meters to now we'll be hearing about military and overseas operations in general, hearing about hospitals and prisons. I think it was very helpful to bring the people together in a conference like this. Before I turn to substance, I should say one little quick story, if I could tell you, maybe my favorite story from my time in the White House. I don't know how many of you know Washington well, but I was walking out of the White House complex one evening the last summer when I worked there, it's 2 summers ago now. About 7 in the evening, I'm walking out of the gate onto that part of Pennsylvania Avenue that is only open to pedestrians. I'm walking out, I get to the gate, I open it, and just as I'm walking out, looks like a family is walking by, a mother and a father it looked like, and 2 little children. The younger kid was maybe 4 years old, a boy. He looks up at me, opening the gate to get out of the White House complex. Behind me is the White House already lit up because it was about 7 in the evening. He looks at me, his eyes get big, and I can hear him because he's very close to me. He turns to his father, and he says, "Daddy, is that President Obama?" Father caught my eye, and we both burst out laughing. I feel like saying, "Kid, where do I begin to tell you the differences?" It is particularly interesting for me to take part in the conference and to listen to all the speakers today because I am at GW now, GW Law School, as the Associate Dean in the Government Procurement Law Program, and we have the honor of being essentially the only law school in North America that has a program devoted to government procurement. One of the things that's particularly interesting in the world of government procurement is that it is at the intersection of law and policy and business. And when we do programs, we always bring in people from the government and from private industry. I think the perspectives are healthy. And the one thing I regretted today, even though every single speaker was interesting and I wouldn't have lost any of those speakers, I wish there had been time to also bring in a couple more people from government, both state and federal, and a couple of people from private industry. I think it would have enriched the discussion. We certainly find it enriches discussions that we have at GW Law School. That said, I want to step back and say a few words of framing, at least on the federal level. And I have to tell you, I know the federal level pretty well. The state and local level, I don't know well, which is why I felt like I was learning from every word I was hearing during the conference today about state and local governments. The 2 facts to remember, if you will, is that over the past 20 years, under both Democratic and Republican administrations, until this one, over the past 20 years, federal spending on contracts has consistently gone up year after year. There was one glitch in '97 where it didn't go up. But essentially, from '92 until 2009, spending went up, and pretty darn dramatically. So that when this president came into office, the federal government was spending something like $550 billion US dollars a year on contracts, goods and services. That's one fact. If you think of it as a line going up, up, up. Associated with that, unfortunately, was a line going down not quite so dramatically, not quite so steep, but very relevant to today's conference. And that is the number of people in the federal acquisition workforce, as we call them. That is to say, federal employees who handle contracts. Their numbers started going down in the early 90s and kept going down all through the Clinton and Bush administrations. You can see what happens, or you can guess what happens, if you outsource an enormous amount of government work to contractors, which is what was happening, but you cut back on the people in the government that are awarding the contracts and are supposed to be overseeing the contractors. It was a recipe for bad things to happen. And in fact, as you know, bad things happen, whether in Abu Ghraib or in this country. Most contracting takes place in the Department of Defense for the federal government, and therefore, the pattern that I'm talking about was most obvious in the Department of Defense, both overseas, but also in the United States. When this administration came in, it was committed to cutting back spending on contracts and increasing the size of the federal workforce that handles contracts, if you will, correcting both of those lines. What we weren't committed to, although people thought we would do it, was doing massive insourcing, the way the two prior administrations, Democratic and Republican, had done massive outsourcing. Many people thought we were going to do it, because privatization, a term that's, by the way, somewhat ambiguous in this area, but let me say the use of contractors had become so prevalent that people thought there were problems and that we were going to dramatically cut back in the use of contractors. We didn't do that. If this conference had been held 10 years ago, I think that the use of contractors would have had a big question mark after it. Is this a good or a bad thing? In this administration, I think to the surprise of many people, there has not been an effort to dramatically insource, to dramatically cut back on the use of contractors, at least on the federal plane. I don't think that there is a question about whether we should use contractors. Contractors do a good job, not in every case, not every contractor, obviously, but overall, the reliance on contractors is in my opinion, widely viewed as a good thing. That's true whether you ask our service members in Iraq and Afghanistan whether they like the fact that contractors set up their showers, their mess tents, and whatever, and the answer will be, you bet we do. That's true within the United States as well. It's true at USAID in its widespread use of contractors overseas and the Department of State. There are problematic areas, and I think you're going to hear about some of them today from the rest of the panel. I'll mention that security contractors have been a particularly sore point and a very tricky one. But overall, we view the use of contractors as a good thing, and it is, in my opinion, not on the table as a policy question. Although I think there's some people, especially in the Democratic Party in the House and in the Senate, who think that it's actually an open question. I just don't think they're right. That said, there are some problems that are worth pointing out on a high level, and that is we sometimes use contractors for bad reasons. A couple of them got alluded to earlier in today's discussion. Let me just remind you of what you heard and add a couple more. We sometimes use contractors because it's quicker to hire a contractor, if you will, to award a contract than to hire federal employees, a notoriously slow process. Even more problematic, it's easier to get rid of a contractor, or particularly a contractor's employee, if you're not happy with her or him on the job, than to get rid of a federal employee. That federal employee has, and rightly so, I might add, civil service protection. But if Joe, who works for a contractor, is working in your agency's offices and you're not happy with Joe, you call up the contractor, say, Joe's not working out. Joe's going to be gone the next day. May still be working for the contractor, but won't be in that government office. You can't do that with civil servants, and it's good that you can't do it with civil servants. There are other reasons that we use contractors. You may know that the Wartime Contracting Commission use a phrase which I liked. There were other things in the report that I didn't like, but they talked about the use of contractors by DOD overseas having become the default option, one that is taken without thought, and I thought that criticism is well put. Why do we use contractors instead of civil servants? I've given you a couple of reasons. Why do we use contractors instead of service members? Because of the national policy, if you will, that we don't want our military to get larger. That's one of the reasons that we have the log cap contract that provides all sorts of support services, so that we no longer have soldiers peeling potatoes the way they would have in prior wars. We have contractors that peel the potatoes and cook the meals for our soldiers. I should note in passing one other thing that's a little bit outside my turf, but it's an interesting point, and that there is a tendency today, more than in the past, to move from contracts to grants and other forms of assistance. It's particularly noteworthy in agencies such as HHS and USAID. It's problematic, especially because the reason it's happening, in my opinion, often has more to do with the ease of awarding the ease of awarding grants than any particularly good reason. I've talked to contractors in the development business, USAID contractors, who tell me they used to do particular work under a contract, now they do it under a grant. Same work. There's less regulation of grants, there's less oversight in grants. OMB recently announced an initiative to improve the regulations governing grants, but I have to tell you it's an area where both Congress and OMB need to do a better job, because there's leakage that is unsupervised leakage, in my opinion, from the contract world to the grant world. The one other thing that I would add is that there is a tendency to focus on the award of contracts, competing for the award or not competing for the award, litigating about the award through bid protests by disappointed bidders. That area happens to be heavily lawyered and gets a lot of attention. Both overseas and in the United States, we tend to neglect what comes before and after that. What comes before is acquisition planning. It's doing a good job of writing what the government actually needs, especially in services. The government tends to do a bad job of defining its needs, and if you don't define your needs clearly in your contract, you risk having problems down the road. And I should have noted at the beginning, let me note in passing now, that one of the big changes in the last 20 years in the federal procurement system is that we've shifted from mostly buying goods to mostly buying services, the very area where we're not good at writing our requirements. That's before we award the contract. After we award the contract, we need to manage the contractors. We're very bad at doing that. Our people are understaffed, they're undertrained. For many of our contracting shops, their view is they sign the contract, our job is over. That is particularly problematic in wartime, when you have situations where you have a contractor out there potentially interfacing with civilians in a hostile environment. If you're not doing a good job managing your contractors, you risk having problems, and we don't do a good enough job managing our contractors. Let me do this. Let me stop here. There's one. Let me leave you with one little factoid, which again I think demonstrates what has happened in terms of our reliance on contractors. You all know that there was a lot of political controversy over the last month or two about the murder of 4 Americans in Benghazi, including our ambassador. It turned into a political football for reasons that were, in my humble opinion, completely unjustified. What people don't often think about, don't even know, is that of the 4 Americans who were killed in Benghazi, 2 were federal employees, 2 were contractors. That number gives you a sense of how much we rely on contractors every place, whether it's in our embassies, whether it's in the military, or in our development effort overseas. Let me stop there so I don't go over time. Thank you very much.
Thank you very much, Dan. John?
Thank you, Charlie, and thank you. I just wanted to also thank the Thrower family, as everyone else has. This is an incredible opportunity for me, and as I think others have also mentioned, I would speak for my colleagues in getting to collaborate in an event like this, and I think it's also, I hope, good for the students as well. And I just wanted to both thank the Emory Law Journal students, particularly Jesse Brown, for their hospitality. And I also wanted to just punctuate one point that Dan made, particularly for students who may not understand this. Dan prefaced, or he when he was talking about civil servants being not at-will employees. I mean, one of the chief advantages, at least as I see it, and in case it's not apparent, is that particularly in regulatory agencies, a civil servant who has job protection can give some pushback to the political leadership, particularly when that political leadership might be trying to cut corners either procedurally or maybe trying to push a hyper-politicized agenda. So I just want, in case that wasn't clear, maybe why we value it. You might be more familiar with kind of the academic freedom associated with tenure in the universities, but I think that's one of the principal reasons why people prize the civil service tenure, even if it means there's some inefficiencies at the margin. It's also a question that's based on this, the panel topic. The question that I kind of want to cover is how to hold military contractors and other private actors advancing national security aims accountable. Of late, the standard approach has been focused on prosecuting wayward military contractors, seeking to impose criminal, civil, or even regulatory sanctions to punish past acts and to deter future ones. And there's lots of scholarly, legislative, and judicial resources that have been poured into such efforts. Yet, as Charlie mentioned in his opening remarks, and as Judge Kaczynski mentioned this morning, there are a lot of stumbling blocks to effectively prosecuting overseas contractors, including the jurisdictional and constitutional questions that Charlie alluded to. Evidence might be scant, and overseas witnesses are hard to come by and perhaps unreliable. So because liability is so elusive, I'm tempted to go back to basics of kind of privatization 101, as it were, and to think about how we generally hold contractors accountable in ways that negate or minimize the need for complicated and potentially unsuccessful lawsuits. So typically, we ought not contract unless two conditions are met. First, the contractors should be subject to political controls, and second, the contractors operate within a competitive market. Both of these preconditions, as it were at least alluded to, if not directly mentioned by other panels today. The reason for political control, I think, is intuitive. We want to make sure that those advancing government programs are subordinate to and responsive to the governmental leadership. Otherwise, we'd be worried they're capable not just of slacking off, but actually shifting policy priorities in a different direction. That goes back to what Sasha Volokh was saying. Tell me what beans I'm looking for, and I'll count them. Or I totally botched your much more succinct and comprehensive metaphor, but we worry about that if there's a disconnect, a contractor might shift policy priorities in a way that it comports with either one's bottom line or perhaps even an ideological perspective. The reason for competition is no less important. The perceived benefits from choosing a contractor over a government agent turn in large part on the contractor operating in a competitive market. The competitive market ensures that contractors remain efficient and more or less honest. Because if not, and if it's a competitive market, any number of rival firms would seize the opportunity to unseat that incumbent contractor if it is inefficient or abusive. But if there's not a credible threat of ouster, that there's no one else to fill in, and we talked about the earlier sessions talked about the need to have replacements at hand, the contractor has comparatively fewer reasons to strive for excellence. So thus, in theory, if we connect political supervision with competitors capable of kind of nipping at the incumbent contractor's heels, we should keep contractors on the straight and narrow. But I actually worry that just doesn't work in a national security context on either level. So let's take competition first. It makes all the sense in the world to insist that private sanitation, catering, even prison personnel operate in competitive markets. Those markets exist. There's other jurisdictions, so there's a neighboring town. There's also private consumers or customers of those services. So there's a vibrant market such that if any contractor, any would-be contractor loses out on a given contract, it's not going to go out of business. It's going to find other opportunities. It's going to continue to kind of hone its business model and be ready to pitch a new proposal if and when the incumbent's contract expires or is terminated for cause. But if there's no such broader market, as I said, the incumbent contractor would be peerless. But in the private security forces area, do we really want our private security firms taking on other clients? If they're doing specialized military and intelligence work, operating essentially at what folks call the tip of the spear, as opposed to just setting up showers and latrines and food services. First of all, we hope there's no real private demand for such services. There are potential public customers, and that's a different question. Do we want our contractors also working for other states? The history is both near and old, are replete with examples of mercenaries selling their services to the highest bidder, and then sometimes transferring intelligence, or at worst, switching sides mid-battle. Though I'm confident nothing like that so drastic as switching sides would happen with an American contractor, there is still the concern about firms cozying up with other nations that might be now or in the future strategic rivals to our own. One only need look at the Arab Spring and its aftermath to see that there is indeed a strong foreign demand for military contractors, and also to realize how quickly events can turn loyal, if internally repressive allied states could turn into regimes that are at best cool and at worst hostile to our own interests. So what this means is we really can't, and we don't, encourage competitive markets for military service contractors. And as such, we have to not only pay our firms more because they can't rely on steady work from anyone else, it also means that those who lose out on federal contracts are at great risk of going out of business. Now, if it's a conglomerate, I just mean that that particular military service unit would go out of business. And those that do receive the contracts are relatively immune from government sanction to the extent the other companies kind of fall by the wayside. Consider the case of Blackwater. It's an open question why, for instance, as late as 2010, the Obama administration continued to work with Blackwater. You might recall various little data points about Blackwater. Maybe Laura's going to get into them more, but it's kind of notorious for its role in killing of civilians, both in Afghanistan and Iraq, for developing a program to locate and assassinate key Al-Qaeda officials back when that was kind of controversial, and for its participation with the CIA in offensive raids throughout this past decade. Whether justly deserved or not, Blackwater had a toxic reputation both domestically and particularly within the countries they were operating. And it raises the question why we wouldn't keep our distance. But we continue to do so, and it signaled to Blackwater and other contractors as well that the United States isn't prepared or isn't able to take a hard line when it comes to abusive contractors. We were simply reliant on them. So we're faced with a dilemma. Absent robust competition, we don't have ready quality replacements for military contractors, but we also don't want robust competition because that means the out firms will need to find alternative employment. Now, there's a third, not mutually exclusive possibility, which is to hire a bunch of little firms and cultivate little firms. But then there are questions of quality control. Who are these little firms? Do they have the capacity we need? That's one of the reasons we went back to Blackwater. They had the experience and they had the size. And then there's cost. There's no economies of scale with a bunch of small fry companies. And there's a parallel to this in the procurement area where, for economic reasons, the major kind of military hardware, aircraft companies like Lockheed and Boeing, they were decades ago, they were all forced to consolidate because the economy wasn't just big enough to have a bunch of smaller firms. And now we don't have that many options if we don't like what Boeing and Lockheed are doing, particularly when they issue joint bids together. The case against political control is admittedly a much tougher sell. So my position here is more tentative. Of course, civilian control over the military is a hallmark feature of Western liberal societies, including ours. Among other things, our laws take care to make sure that military orders originate with the president and are disseminated through the civilian Secretary of Defense. And to further booster the civilian nature of the Secretary of Defense, Congress requires that any Secretary of Defense be at least 10 years removed from active service. So it seems like a no-brainer, especially given what I was saying before about why we want political control, that we want political control in this context, which, as Charlie referred to, we often consider core, inherently governmental. We certainly want it over military personnel. It should follow even more strongly that we want it over contractors. But I have two concerns that at least muddy the waters in my mind. The first is a general concern about contractors acting unprofessionally and potentially abusive, particularly hostile to local communities where they're operating overseas, and they're poorly integrated with the regular military. Given, by contrast, the military's highly regimented, disciplined practices and strong esprit de corps, were contractors directly subordinated to the military instead of to the civilian leadership as kind of two parallel chains of command, the military code of professional conduct might rub off on them more fully. This also goes back to some of the doctrine that Judge Kaczynski was raising before when he was comparing the Filarski case with Richardson. One of the concurrences in Filarski, I believe it's Justice Sotomayor's, justified the extension of qualified immunity to contractors precisely because, and again, this isn't the majority opinion, but this is her reasoning, and I think it's persuasive, precisely because the independent investigator was closely supervised by government employees, whereas in Richardson, it's a private prison, kind of isolated, and it doesn't have immediate supervision by government officials. I would think that kind of integrating better the contractors into the military chain of command would be beneficial, particularly in situations like we've discussed about in Abu Ghraib. One certainly can't blame contractors alone for the horrific acts that took place there. But all of the subsequent government investigations indicated that the existence of contractors and the separate military chain of command created disruptions and undermined order and discipline. So as much as we associate legitimacy with unmediated political control, having contractors directly accountable to the civil leadership and somewhat divorced from the regular military is a reason why direct control in this context, for me, is at best a mixed bag. There's a second reason why I'm worried about political control. Assignments may go to contractors either because the law doesn't as stringently regulate private actors, and the administration is trying to work around, say, congressional restrictions or even the Uniform Code of Military Justice, or because the military establishment, if given those questionable assignments, would provide too much resistance. Recall that it was military officers and lawyers who pushed back against some of the White House and Defense Department-led approaches to such issues as rendition, enhanced interrogations, and detentions. Again, the military has this kind of both this independent credibility, notwithstanding its subordination to the civil leadership, and the challenges of removing wholesale military officers makes them have an independent credibility and an investment in ensuring kind of the ethics and integrity of their agency, their departments. So in these cases, though, where I'm saying that using contractors to kind of skirt regulations that govern military personnel or just state actors in general, these contractors would actually be following orders, perhaps to a T. So they wouldn't be wayward contractors in the way we think of normal principal agent problems and the agent going off on a frolic and a detour, but they'd be enabling problematic governmental action. It's a different but no less troublesome phenomenon, and one that even if we could easily sue contractors, wouldn't remedy the situation. So this all said, I'm not so sure. I'm questioning political control as well, and I think this leaves me with, in effect, that we're damned if we do and we're damned if we don't. So for those of you hoping or expecting that I would provide structural paths to effective contractor controls, I'm sorry to disappoint. I think they remain elusive. And I continue for that reason to believe that the practice of military contractors remains an untenable, if not indefensible one. Again, military contractors at the proverbial tip of the sphere. Fortunately, for a variety of reasons, we're downscaling our military presence in Iraq and Afghanistan, and thus have an opportunity to end our decade-long dependence on military contractors. To be sure, the impulse will be to downsize the military because of combat fatigue and insufficient mental health and economic services for servicemen and women and their families, it'll be hard to ramp up our public fighting forces were the need to arise in the future. The easy path will once again be to hire contractors. The better, though harder path will be to rebuild a public military that is readily constrained by a variety of disciplinary mechanisms that work both on the structural and legal level, and that perhaps negates the need to employ contractors in such sensitive positions.
So I'd like to echo others and thank the sponsors of the symposium, the students of the Emory Law Journal, the Emory faculty. It's really an honor to be here. It's been a terrific day, and I think it's produced a very rich debate on the topic of privatization. The growing use of contractors to provide government services, particularly in the sphere of military and foreign affairs, spurs us to consider new forms of blended public-private governance and oversight. As John and Dan have noted, particularly in this area of military privatization, the traditional mechanisms of public oversight and control and accountability are often unavailable, including litigation. It's very weak, ineffectual, and so we need to look to other avenues if we want to protect core public values in an era of privatization. Now, in my own work, I've long argued for this, that we need to look towards new mechanisms of accountability and constraint in this area. And in particular, I've argued that human rights groups that want to protect human rights values and, for example, hold military and security contractors accountable to human rights norms, that they should go beyond traditional mechanisms like, for example, working towards developing new treaties, and look towards other things, such as developing codes of conduct, reforming contractual terms, including human rights provisions and contractual terms and oversight mechanisms, and also in developing accreditation regimes. Well, remarkably, we actually have such a new regime on the table. The draft International Code of Conduct for private military and security contractors, private security contractors, and a governance and oversight mechanism to implement that code. And this has been the product of many years of work by a very diverse group of stakeholders, governments, civil society groups, in particular human rights organizations, and the industry itself. And I think, while it's not a panacea, I do think it holds considerable promise. So I want to spend today talking about this. And I'm going to first describe the Code of Conduct and the draft oversight mechanism in some detail so you can understand how it works. And then I'm going to evaluate it in light of core public values. I'm going to focus on human rights and human dignity, as well as the values of global administrative law, namely public participation, transparency, and accountability. And I'm going to look both at the process by which this mechanism was created, as well as the substantive terms and procedural terms of the code and the governance mechanism itself. So let me start by describing a little bit about how this came into being. It really was an initiative started by the Swiss government and the International Committee for the Red Cross. When contractors were being used in the wars in Iraq and Afghanistan, it became very clear that the existing bodies of international humanitarian law and human rights law had significant gaps in them as they applied to contractors. There were many gray areas. And so the ICRC, which is charged with monitoring and implementing international humanitarian law in partnership with the Swiss government, developed this initiative, really first to take the principles of international humanitarian law and articulate how they might apply to contractors. And this was a multi-year process that involved experts, civil society groups, the industry, many governments, and culminated in something called the Montreux document in 2008, which was not a new treaty, but rather a derivation of principles from existing treaties and application of those principles to contractors in these new contexts. But it became very clear that this was not enough. In particular, for private security contractors, there was a need to have a more specific application of these principles. And so the initiative continued, and the Swiss government got the UK and the United States on board. Industry continued to be at the table, along with human rights groups, in the development of a more specific and detailed code of conduct for the security industry. And I should note, by way of disclaimer, that I've been involved at various stages in the process. I was involved in the Montreux process, and I have been involved to some degree in this process of developing the code and the oversight mechanism for enforcing it. So substantively, let's look at the code and the draft governance mechanism. So the code draws its normative commitments from international humanitarian law and human rights law. And any company that signs onto the code has to agree to abide by these principles. And it's very, very specific and detailed. And it makes it very clear that private actors are bound, which is something that is ambiguous in existing international humanitarian and human rights law. So, for example, there are very clear prohibitions on the use of excessive force. Companies, they shall not use force beyond what is strictly necessary. The force has to be proportionate. Firearms can only be used in self-defense or defense of others facing imminent threat. And there's also a very clear prohibition of torture and cruel, inhuman, and degrading treatment. Again, in the existing treaties, there is at best ambiguity about whether private actors are directly bound and prohibited from committing torture. So here they are very clearly prohibited from doing so. The code also prohibits sexual exploitation, human trafficking, forced labor, and child labor. Now, by signing the code, the companies not only make these normative commitments, but they agree to make certain organizational reforms to implement them. So specifically, they agree to vet their employees, to make sure they don't have criminal records, to make sure that they haven't engaged in past human rights abuses. They agree to train their employees, incorporate relevant provisions of the code into individual employment contracts, engage in responsible weapons management, report all incidents involving the use of firearms, and establish internal grievance mechanisms so that third parties who might be injured by the contractors can present their complaints to the firms for resolution of disputes. They also agree to protect whistleblowers, something that is, again, not clearly protected under domestic law. So as you can see, this is very detailed and specific, but of course there's no enforcement component. So the initiative continued to develop an actual governance and oversight mechanism to implement the code. And I'm just going to say a few things about that. The main decision makers, or the main implementers of this draft governance and oversight mechanism are a 12-person board, which has representation for 4 members each from the human rights community, industry, and the government community. And so from these 3 broad groups, governments, human rights organizations, and civil society groups, and the industry, many entities can become affiliated with the code and the regime if they meet certain criteria, and then each group elects its board members. So it's a fairly diverse, multi-stakeholder board. And all the members participate in the annual plenary, but the board is the one that really takes the decisions, and the board also is responsible for hiring staff, including an executive director and a chief of performance assessment. Now, the oversight mechanism has 3 basic functions: certification of companies who sign on to the code, ongoing performance assessment of those companies, and assistance in resolution of grievances. Now, with respect to certification, what that means is that companies who sign on to the code are submitting to be monitored and independently examined to see if they are doing everything that they say they're going to be doing under the code. And the draft mechanism says that the board is going to select independent monitors to do this certification process, to go in, go to headquarters, in some cases go to the field, and look at these companies in action and see whether they are vetting, training, doing all the things they say they're going to be doing under the code. So they need to get certified to become member companies, but then once they are certified, they have to agree to periodic performance assessment. And there's some ambiguity about how often this is going to take place. Not all companies are going to get assessed at all times. But they have to agree to be audited by these independent monitors when the chief of performance assessment decides that they should be audited. And this gives a lot of discretion, of course, to the chief of performance assessment. And he or she is supposed to provide an annual report on this process. Now, in addition to this periodic reporting, there is a process called specific compliance review. So if there is a serious incident, take, for example, the infamous incident involving the Blackwater security guards working for the U.S. Department of State who killed civilians in Baghdad's Nisr Square in 2007, an incident like that, or a much less high-profile incident that could trigger a specific audit based on that specific incident, which is supposed to produce a report to the board and a remediation plan that is subject to independent verification. And then, of course, there are the possibility of sanctions. In this case, under the regime, sanctions would include suspension or termination from the regime, which could have consequences in terms of the firm's ability to get or maintain contracts from governments or indeed from the private sector. And then finally, the governance and oversight mechanism provides for a grievance process. This is really the least developed aspect of the regime, and a lot needs to be worked out here. But basically, the companies agree to let the board and the executive director facilitate the resolution of disputes from third parties who might be injured by security contractors. So they can file complaints to the mechanism, and then the mechanism staff can either, support the company's individual grievance mechanism or directly resolve the disputes through a process that the executive director initiates or through mediation, which the mechanism can provide a forum for and support. There's also an annual reporting process for these grievance proceedings. The executive director has to provide an annual report on all the grievances, not on the individual grievance processes, but kind of overall in the aggregate, what kinds of complaints are there, what kinds of resolutions are there to these complaints. Okay, so now I want to turn to look at how well the code and the governance mechanism kind of reflect and promote core public values, namely human rights, human dignity, and then public participation, transparency, and accountability. And I want to look both at the process for creating them and the substantive and procedural terms themselves. So the process is pretty good, I think. You know, it's a broad multi-stakeholder initiative. Multiple groups created the code and the draft oversight mechanism. On the human rights side, Human Rights First, Human Rights Watch played a leading role, but other groups were involved, Amnesty International, the Project on Government Oversight, and many, many other organizations and experts. On the government side, you know, you had the Swiss government taking the lead, United States and the UK. Industry participation very, very broad, both by individual companies and industry associations like the British Association for Private Security Contractors, the IPOA and ISOA, our domestic association for private military and security contractors. Could it have been broader? Yes. You could have seen greater representation of developing countries, perhaps broader civil society groups, but it's pretty significant and pretty broad that you had this large group involved. Also, multiple drafts of all of the documents were made available, so transparency was quite good. In fact, there was a formal notice and comment process, in fact, which is much more than our own Department of Defense likely would have done for a comparable initiative. So I think that that is quite significant. If we look at the substantive terms of the code and the oversight mechanism, how do they stack up? Well, human rights and human dignity is fairly carefully protected. Normatively, it's very, very strong, very specific, very clear protections for specific human rights. With respect to public participation, it's also quite good. Again, we have a multi-stakeholder board, an opportunity for a very broad array of groups to become involved. Right now, we've got 592 signatory companies from 70 countries. And then on transparency, I would say it's fair. We've got annual reporting on the performance assessments and also on the grievance processes. So transparency is fairly good. And then finally, on accountability, I think it's fairly strong. I think we should separate out two different kinds of accountability, which I think often get confused in the privatization literature, or at least muddled. Managerial accountability or oversight and post hoc redress of grievances. And with respect to managerial oversight and accountability, we do have this independent monitoring function, which others mentioned earlier in the day, which is significant, and I think that that is a very strong component of the regime. With respect to post hoc accountability, I think we can only say that it's fair. You know, there is an internal grievance process that the companies have to have, and this possibility of mediation. Obviously, it's not a replication for litigation, but I think it is significant that is there. And then in conclusion, I just want to say, you know, there are some lingering issues, of course. Most notably, will this mechanism have the resources it needs to really do the work that is there for it to do on paper? There's a dues-paying system for gathering resources, but will it have enough in the end to do its work? And then, you know, are governments going to condition membership in this regime on the award of contracts? Now, Great Britain has signaled that it will. The U.S. government has not said that it will, although Department of Defense officials have said to me that they've made it clear to companies they should take this very seriously. And I've spoken with people in the industry who said that that they are taking this very seriously. But I think, it remains to be seen. And then another point is that the private sector may actually find this regime to be very useful. And I've heard from that some in the extractive industry are looking to this to determine whether it will be a way for them to select which security contractors they will use. So in the end, I think it's quite a bit stronger than many comparable initiatives, and I think it holds a lot of promise. I don't think it's a panacea, but I think it's a really important way forward in this complex area of foreign affairs privatization. Thank you so much.
Okay, we're going to take questions now. You can direct them at any of the panelists or all of the panelists. Before we take questions from the floor, though, I just want to say one thing that's kind of been nagging at me through all of this, and that is the law of unintended consequences. The law of unintended consequences says that the more you try to do something well, the more other mechanisms might move to change the mechanism that's being well regulated. For example, instead of contracting out things from government to private vendors, maybe we ought to just outsource the whole thing altogether. I think it's arguable in the military context in Afghanistan. That's what we did when the Soviets were there. Instead of providing any services or any military or even any American contractors, we'll just give guns to jihadis. Okay? Would any of the three of you all like to comment about the possibility, at least, that regulations and controls in these areas might produce such unintended consequences? No.
No, I'm happy to say
Next
a couple words.
question.
No, it's a very interesting question, Charlie. Can I answer a question? Can I answer the question by asking a question?
Sure.
And
And
in fact,
I'm sure someone in the audience
well, no, I'm
will
going to
raise
ask
their
John,
hand to answer it.
actually.
Okay, go ahead. Go ahead.
Because I'm a little bit worried that the students in the audience, in particular, might misunderstand what we're talking about when we talk about private security contractors. This is not a battalion of soldiers that are supplementing the American Armed Forces. They're private security contractors. They are a cousin of what you see in any federal office building where you have Wackenhut or some other company guarding the building. It's true that they are armed. By the way, so are the Wackenhut guards at federal buildings. But they are not there for combat purposes. They are prepared to use their weapons, and there have been instances, both Laura and John, I think, alluded to them, where they've used their weapons inappropriately, and the question is, how do you hold them accountable? But these are guards. By the way, they are typically, I don't know the statistics, but many of them at least, are former members of the American military. And I wanted to ask John, is the problem perhaps both a little bit less serious and somewhat more serious than your description, if I can? And I think it's actually building on your question. One, since these aren't actually a battalion of soldiers out there, it's not quite as bad as it might sound. That's part of it. Two, when you talk about competition, the fact is, as you know very well, that in DOD you're very often dealing with only two possible contractors, Boeing and Lockheed, or Northrop Grumman and BAE Systems or whatever. So the fact that you don't have much competition, and the fact that the fact that there's no commercial market is actually not that unusual. And incidentally, for security contractors, there actually is a fairly robust private market, because lots of entities need security guards, including in the United States, but also overseas. But then my question is it perhaps somewhat worse? This actually relates to your point as well, I think. You said, well, the good news is the war is winding down in Iraq and Afghanistan. But in fact, the State Department and USAID use large numbers of private security contractors, and my understanding, at least, is that they're not nearly as good at managing the private security contractors as DOD is. So should we perhaps be more worried then you were suggesting that what's about to happen is the world of private security contractors, which is a tiny part of federal procurement, by the way, but it's going to be not managed by DOD. It's going to be managed by people who aren't good at managing any contract, especially contracts with guys with guns. USAID and state. Oh, Laura wants to respond.
Well, no, do you want to go first? Or?
You may go first.
Okay, well, first thing, the part where you said it's better than we might think, I'm not sure I agree with you there, because you said something like most of them are U.S. citizens and they're just security guards. You know, some of the data suggests that as many of 80% are not U.S. citizens. They're third country nationals. They could be host country nationals, or they could come from all around the world, from Fiji to Uganda, South Africa. Some of those individuals are quite competent, but nonetheless, it presents enormous problems for regulation and oversight when you think of the diversity of nationalities of those security contractors. And although we officially don't allow the security contractors to do more than defend, in many cases, the boundary between defense and offense is really unclear. So I'm going to give you an example from Najaf where, you know, at a military base, security guards were guarding the perimeter of the base, and there was a kind of a menacing crowd gathering outside the base, and one thing led to another, and suddenly the security guards were firing on the crowd. Now, probably they were provoked. The crowd was probably very dangerous. There was one uniformed military person there, and he was effectively, according to after-action reports, kind of taking orders from the contractors until troops could arrive. And so that's an example of where, when you're in a hostile environment and you have a lot of security contractors, defensive operations can slide into offense. And then finally, I do agree with you about the State Department issue. You know, after the Blackwater incident in 2007, there was kind of a wake-up call to the Defense Department, State Department, our government, that we needed to have better regulation and oversight. And there was a decision to give DOD the lead on this. And there are jurisdictional ambiguities in the criminal laws and so forth. But managerially, DOD was given the lead. And now, as DOD draws down troops, and we've got this expansion of, you know, the role of the State Department and security contractors all around the world, that's a real problem. And also, the jurisdictional ambiguity remains. It's very clear that if a contractor is working for the Defense Department, the federal courts have jurisdiction over a crime committed by a Defense Department employee committed overseas. It's not clear. The language is, anybody whose employment relates to supporting a Department of Defense mission. Well, if we're not in a clear conflict and the State Department has control, it's very ambiguous as to whether U.S. courts would have jurisdiction over crimes committed by contractors working for agencies other than the Defense Department.
Okay, I sign on to most of what Laura said, and but with all that in mind, Dan has a point. I did not mean to suggest that we had kind of, you know, a 300 grouped contingent going out on raids, and I apologize if that's what was intimated. At the same time, as Laura mentioned, there's a fine line between security sweeps and offensive missions at times. And when you do a security sweep to patrol a perimeter, and that perimeter gets bigger and bigger, it gets pretty close to at least putting yourself in a situation where crossfire and you know, combat might occur. A couple other quick points in response to Dan's incredibly thoughtful set of questions is the market, and I completely defer to Dan and Laura on the question of how broad the market is. Some of the market, though, I think is an opposite, like, for instance, working in kind of corporate security and for Disneyland, and it's true it can keep you in business, but it's not the same skill set, and I don't know how much we trust kind of the fungibility of those sets of contractors. But again, I defer if my information is or my intuition is wrong. I do want to echo the point about the kind of the complications of having multiple agencies managing contractors. In point of fact, the Abu Ghraib contractors were on Department of Interior contracts, as I understand it. U.S. Department of Interior as information technology consultants who were then kind of dispatched to the Defense Department and then dispatched to Iraq. And the hearings, the congressional hearings that immediately followed that, I remember then Secretary Rumsfeld sitting with a couple of generals, and the members of the Senate, it was John McCain, kept on saying, how many contractors do you have? And they looked around to each other, they looked back to their aides, so people who usually know these numbers, and the Senator, we don't know. We can't keep track of everyone. So to the extent the Defense Department may be able to keep track of who they know is operating in what place, it may not be a battalion, but it's a whole plethora of people that are kind of interspersed within the machinery of the Defense Department, and a lot of times, if not on the front lines, really close to the front lines. Charlie, may I pick up on this proxy war issue? Which I think is
I do want to say, does anybody have any questions from the audience? Okay, well, go ahead.
No, students, I'd be very happy for students to jump in.
Okay, go right ahead, sorry.
Is there a question?
There's a question.
If you have a question, please come to the microphone, and then we'll know that you have a question, okay?
I just have a question. It's been said that most of the cases involve more of the mundane security contractors that are at embassies and other U.S. government.
Speak up a little bit.
That most of the cases are rather simple. They're security contractors at U.S. embassies and other government installations. But for those of us that sort of came of age during the War on Terror, a lot of the more marginal cases that we think about are the controversial ones. And when we discuss accountability and different ways for governments to place accountability on contractors and for aggrieved citizens and victims to perhaps request accountability, Professor Dickinson mentioned that in these new codes of conduct internationally, the Department of Defense really hasn't come through with enforcement mechanisms, and on the grievance process, there hasn't been complete follow-through. So my question is, what sort of mechanisms do aggrieved citizens have when there's a complete lack of civil liability, for example, in this area, since the courts have interpreted the lack of that extremely broadly? What mechanisms are there? What of political will is there for such accountability? Thank you.
So we can look to civil liability or criminal liability, and there are many civil lawsuits percolating their way through the courts, and they're meeting with a lot of defenses, including political question, doctrine, the government contractor, immunity, preemption defense. There are some cases that are proceeding, and there are some cases that have settled, but it's really unclear how viable tort liability is for these kinds of cases. I wouldn't say it's a dead end, but it's not a clear path to liability. On the criminal side, there have been some prosecutions, but there have been notable difficulties. So in the case of the Blackwater incident from 2007, there was a really botched investigation that screwed up the prosecution, not completely, but it's still ongoing. But lots of people were running around purporting to, the State Department officials were purporting to give immunity to the contractors, and then the case was built on those immunized statements, and so that was a problem. Evidence gathering is a difficult issue in these cases, but there's also been, I think, a lack of real political will to prosecute the cases. The Uniform Code of Military Justice has been expanded to allow for military prosecutions of certain categories of contractors, and we've got one case that just went up to the Court of Appeals in the Armed Forces, and they said that it is possible to try civilians in military courts, but obviously that's a really complex constitutional question for us to consider. So I think that this code of conduct grievance process is going to be an important piece of the puzzle. I don't think it's the only answer, but third parties can file complaints under this mechanism and get, some kind of grievance dispute resolution process. And, it's not meant to supersede any of these other proceedings, but I think it's got promise.
May I just add to that? I think I took from your question also, what could everyday citizens who are not directly affected what's their recourse? And I think Laura touched upon it, but I just want to underscore it, which is the political accountability, which is resisting, to the extent, resisting policies that you don't like by making it a salient campaign issue, which it really hasn't been for more or less over the past decade, though there was some interest during the Democratic primary in 2008. I just wanted to add to that, I guess, particularly because this is a student event, and you said you grew up in the kind of post-war on terror era. I would say you grew up you're going to be lawyers in the post-war on terror era. I grew up as a lawyer in the post-war on terror era, which was, I was in law school when it happened, and it shaped my academic and, before that, my professional career as well in terms of what I was doing. This is kind of, it may turn into, as Charlie suggested, it may turn into that we're going to use different resources. We're going to use other countries, like perhaps like in Mali, where and Libya, where we funded and kind of provided logistical support that other nation states were carrying out. It may be that we just directly fund kind of insurgent groups within countries to destabilize governments that we don't like. It may be we create new governance regimes, as Laura was alluding to. But this is kind of a moment, because notwithstanding the fact that contractors are still in the State Department overseas and USAID overseas, the dimensions of war have changed. The emergency conditions, whether real or not, are not as salient as they were 10 years ago. And so I invite that, I suggest as an opportunity for you to explore it on a relatively, but of course not perfectly clean slate.
Well, our time is up, and I know some of you may want to go to the reception, and I think Jesse has a word to say to you.
As Professor Shaner mentioned, there is a reception outside. We encourage you to stay and perhaps ask those questions you didn't get a chance to ask in the auditorium. So again, thank you all. Please go enjoy the reception, and I'm going to ask some questions myself.